Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale where we talk about real-life cases and real-life facts and clients, and they're things that me or my office have worked on. For today's episode, we're going to be talking about something I hear people say to me, to my office, and to others in my industry all the time. What is it? Here's the statement. I just need a really simple will. Now I get it. I promise you I do. We don't have to overcomplicate something that can be and should be quite simple. I agree. I'm a fan of that. Though asking me to draft a really simple will is like telling the person at Lowe's mixing paint that you just want blue paint. Like, what shade of blue do you want? Turquoise? Midnight blue, royal blue. If someone said, Jenny, I'd like you to prepare me a simple will, I'd probably freeze for a second and say, well, I don't know if that really exists. So today's episode is going to be about why I think that, why I say that, and provide some examples on why I think and say that. You know, I think a lot of people say that sentence, that I need a simple will, because they think there's nothing going on with them, or their people, like children or beneficiaries, or their assets that require anything, unique or fancy. I think a lot of people also say this because of my profession too, that they think that, the lawyer is going to just talk above my head and make things way overcomplicated and want to bill me to death. So they just feel like they should vocalize exactly what they think they need. Interestingly enough, most people in front of me have issues or goals that honestly do necessitate further planning beyond a will. Think like a kiddo that is terrible with money, or a beneficiary that has a spouse that you're not too crazy about, or a kid that's into drugs or alcohol or gambling, or a beneficiary that you want to cut out, or whatever. But for the sake of this topic and episode, let's pretend things are really that simple. There's you, there's your kiddos or beneficiaries, and everyone is groovy, and assets are super straightforward. Let's pretend that this is the kind of situation I'm talking about. And even though nothing is jumping off the page, there are still things that even and I'm unfortunately going to say it, a really simple will should maybe have, depending on your beneficiaries. These things are called testamentary trusts. And now don't get lost in the legalese. Basically, a testamentary trust is a thing that is created through a last will and testament, which a will doesn't kick in until after we pass away. And most of the time, we're having to go through probate to kick it into action. As we've discussed on many episodes, wills go through probate, depending on the asset threshold and how assets are owned and titled. But oftentimes these testamentary trusts are created in wills in two general scenarios. First, for individuals that are minors. And second, for individuals that are receiving governmental benefits like Medicaid or Social Security, SSI. While they're created for two very different purposes, they have one similarity. And that is to protect the beneficiaries themselves in your will. So let's talk about both and why maybe you should consider having these even in your, quote, simple will. Let's kick things off with minors, so someone under the age of 18. To really introduce this topic, I think I'll start with a question. What would you, Legal Tea listener, have done with an inheritance at 18 years old? Or even if you would have been wise with it, do you think most 18-year-old kiddos would have? Probably not, right? And that's what this first topic is doing. It's protecting kids from themselves. So oftentimes in someone's will, a client will have me say, okay, in equal shares to my children. And immediately, I always say, well, what happens to one of your child's share if they were to pass away before you? And it's good to do this proactively so you don't have to update your will if something tragic like that happens. Most of the time, clients say, well, I want their share to go to their children. And that is when. So that could be when we start dealing with minor kiddos, that level. And that's, say, your grandchildren, right? So it's quite easy to do in a will. But what can happen is to actually have your attorney build in this testamentary trust that is sort of on standby. Like, if we don't use it, that's fine. But it's there if we need it, to house an inheritance for anyone under the age of X. And you pick what X is. Is it 21? Is it 25? Is it 35? And that may seem old, but I just had someone pick yesterday 35. So what ends up happening is that, kind of logistically speaking, is that the child's inheritance, if they're inheriting, drops into an account, which, yes, it can be invested, that happens to be in the name of a trust, a testamentary trust. Then you put someone else in charge of it, say the child's surviving parent, or maybe you don't like the surviving parent, your in-law, so you put someone else. But nonetheless, that person is sort of your child's moral compass in terms of this inheritance. If that child comes to that person and says, hey, I want money out of my account for a deposit on a Lamborghini, ideally, that person is like, no, kid. But say the kid comes to the person and says, hey, I need some money out of my account for textbooks. Then the person in charge can access the account. And no, the kid cannot access the account. But that person can access the account and pull funds out for textbooks. And insider secret, I tell that person to make the funds payable directly to that textbook store. So the kid doesn't say they need textbooks, but really just want money to buy something silly. So the next thing on things you should consider even in a simple will, what about individuals on governmental benefits like Medicaid or Social Security, SSI? The thing about this topic you have to know and remember is that oftentimes governmental benefits have asset limitations. So if someone walks into an inheritance and is on an asset-based benefit, they could get kicked off of that benefit by receiving the inheritance. So instead of the inheritance going to the individual and supporting them, their benefits get terminated. And they have to spend the money on usually health services. And then when they get through the money, when they spend through it all, then they have to reapply for the benefit and hope they can get back on. The kicker too with this topic is so often people say to me or think, oh, well, none of my beneficiaries are receiving any governmental benefits. But my question for you is, what if they start after you do your will? Like start to receive governmental benefits after you do your will. You see, the example I often give to clients is, when I pull out of the office in the evenings, it's in the middle of rush hour. And, I have to play Frogger to get out of this parking lot. When I start pulling out, what if I get hit and I survive, but I can no longer work anymore due to my injuries? And I start receiving asset-based benefits. There. Now I'm that person I was just talking about. Things change so fast. Then say my parents pass and I'm set to inherit, their assets would fall to me and I'd probably lose those benefits I'm on. Yikes. And that's not exactly the intention of my parents to put me in a bad position, right? Again, like the last testamentary trust we described, there could also be a standby testamentary trust for these situations too, called a supplemental needs trust or a special needs trust. It could be inside your simple will, and if it's never needed, no biggie. But what if it is needed? If it is, we are so thankful it's in there so that the beneficiary is not negatively impacted by your estate. And this testamentary trust works very similarly to the one I just described about young kiddos. That the inheritance would drop into an account, which yes, it can be invested. It can even hold property, like a house. Someone else is in charge, and it's in compliance with federal laws to meet the necessary standards to allow the trust beneficiary, the individual that's receiving the inheritance, that allows them to receive the inheritance and not get kicked off of any benefits that they're entitled to. Win-win, right? So one last topic to talk about on this, quote, simple will topic, which is probate avoidance. I had a financial advisor recently ask me somewhat kind of about testamentary trusts and sort of my general opinion of what, the purpose of them. I think a lot of financial professionals have heard of these creatures, but they miss the point, they miss the piece that they are called testamentary trusts for a reason. It's because they are created in a last will and testament. And if a will is controlling an asset, that means we're likely going through probate. So this piece of the conversation is especially important if you have concerns about minors inheriting or individuals on governmental benefits that are more likely to inherit based on a normal sequence of events. Like, I brought this up earlier, what if your grandkids inherit because your child predeceased you? But what I mean by that last sentence is, what if you have concerns about how your young kiddos, your minor kids inherit? Or maybe you have direct beneficiaries that are already on governmental benefits. If you rely on testamentary trust to accomplish those wishes, that means, one, you need to structure your assets in a way that will actually, your assets will actually flow through your will, because the will is what has the testamentary trust. And two, the will have to get probated to get the testamentary trust created. Probate can be a costly, lengthy, and not very private process. So if you want to provide protection for kiddos and beneficiaries and avoid probate, a super simple living trust, like a revocable living trust, may be more beneficial. I explain it as a teeter-totter or a seesaw. A will is cheaper than a trust every day of the week. So it's cheaper now, but to probate the will later is thousands of dollars. While the trust is more expensive than a will, trusts are always going to be more expensive than doing a will. But trusts do not require probate and not paying those thousands of dollars later. So, believe it or not, oftentimes your estate actually comes out ahead in these situations by doing a trust. As we start to wrap this episode up, I think the big thing to know and understand is this is why there are estate planning attorneys. I know people roll their eyes at me when I say that there's not a simple will. I just truly think there's more than simply slapping names down and moving on. But maybe it's because I've seen so many things go bad and go wrong. So those experiences mold me to how I practice and recommend things to clients. I truly do not mean to overcomplicate things. Instead, It comes from a place of protecting you and your wishes. Alrighty, let's wrap up this episode. Next week, we are back to the current events, current trends topic, where we talk about something I've seen or run across maybe on the news or social media that I think would be interesting on here. During next week's episode, we're going to be talking about an article I stumbled upon about things you can do to your house or look for in a house if you're buying that will support a desire to, quote, age in place. And we're gonna decipher what that age in place really means and what you can do now before that could be something you look at doing. Tune in for that next Tuesday, Legal Tea listeners. Until then, be well and talk soon.